You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 34, Differences between U.S. and PCT applications. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if that's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or you can call me at 424-281-0162. And remember that while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. In the last episode, I went through an overview of what PCT applications are about and why you might be interested in filing one. In this episode, I'm going to go over some differences between US and PCT applications. Some of these are just suggestions and some of these are rules. For the most part, if you just drafted your US application well, it's not going to be that much more work to get your application ready for a PCT application. There are different forms to fill out, which I'll cover in the next episodes, but in terms of the application itself, and what I mean by that are the description, the figures, the claims, there really are only a few things. I'm also going to talk about electronic filing only, which is what you should be doing. If you want more details about the formatting requirements, they're under Rule 11 for the regulations under PCT. Just type in Rule 11 PCT requirements and you'll find a link to them. I'm not going to go over the identical requirements from the US application, just some differences in PCT applications. First, you should prepare your documents on A4 size paper, not US letter paper. A4 paper is what most of the world uses instead of the letter size in the US. It's not that much different. Technically, if you file your PCT application in the United States Receiving Office instead of some other receiving office for a PCT, they'll still accept US letter size, but I'd rather keep it consistent for the rest of the world and just use A4 paper. The margins are a minimum of 2 centimeters on the top, right, and bottom, and 2.5 centimeters on the left side. The maximum is 4 centimeters on the top and left, and 3 centimeters on the right and bottom. For me, if I just make the margins 1 inch everywhere, that works and it's easy to remember. For the figures, the margin should be a minimum of 2.5 centimeters on the top and left, and 1.5 on the right, and 1 centimeter on the bottom. One big difference in theory between US applications and PCT applications is that you're supposed to put in reference numbers from the figures in more places in the PCT application. Let's say you're trying to patent a new kind of keychain, and in your figures you point to a ring in the keychain. You might label the keychain with reference number 10, and the specific ring element you label with reference number 12. In the US, you only need to put those reference numbers in the detailed description of the embodiment section of your patent application. You don't write every reference number in the abstract when you mention that ring and keychain, and you don't write in that reference number in the claims. But in PCT applications, you're supposed to put that reference number wherever you write that element. So if you wrote it in the abstract for the US application, the keychain has a ring, that's fine, but in a PCT application, you're supposed to write the keychain 10 has a ring 12. The reference numbers are supposed to be between parentheses. Only the main features you need to put in reference numbers. I see a lot of PCT applications, even ones that I've done myself, that don't put in these reference numbers, and I've never had a problem with the PCT office saying that it had to be fixed. But once you go into other countries or regions like Europe, they can be more picky about that, so it's good practice to get your PCT application ready for countries that are picky about that kind of stuff. The reference numbers should also be used in the claims as well. It's technically not required by the PCT regulation, but the regulations say shall preferably be followed by the reference numbers. Again, I've never gotten a notice from the PCT office saying that I had to correct claims because they didn't have reference numbers. For spacing, it should be 1.5. In the US, you can do up to 2, but the rule for PCT applications is only 1.5 spacing. Another difference is how the claims should be written. There's a way of drafting claims recommended by WIPO, which stands for the World Intellectual Property Organization. And it puts out the rules for the PCT and it says how claims should be written. And it's a little different from the US claims and more in line with how claims are written in Europe. But it's really beyond the scope of this episode to go into those details. And the rules about how to write claims specifically says that if the national law doesn't require this format, then you don't need to follow that rule. So if you're filing in the US, you can just write claims in the US style that I've gone over before. If you want to look up the details of how it's supposed to be written, it's Rule 6.3 of the PCT regulations. But the point is, the PCT office is not going to tell you to rewrite the claims if you didn't write the claims the way that they say you're supposed to, because they don't know which countries you're going to be nationalizing your application in anyways. It might be too confusing to go into the detailed differences, but if you're really curious about how claims are supposed to be written in the PCT application, it's similar to the European-style claims, which is called a two-part claim. In the US, most people don't do two-part claims. I'm just going to give a really simple example, but I wouldn't fret over the style of the claim. Let's say you have a new keychain that has a ring, a knife, a pen, and a flashlight. Let's also say that the flashlight part is really the only new thing you've added because keychains with rings and knives and pens already exist. This is not really a real-world example of something patentable. I'm just putting parts together. In the US, you might say, I claim a keychain comprising a ring, a knife, a pen, and a flashlight. All those features are lumped together. But the way the PCT technically wants it is in the first part, you say what's already in existence, and in the second part, you say what's new. So you might say, I claim a keychain comprising a ring, a knife, and a pen, wherein the improvement further comprises a flashlight. So what you're doing in the PCT application is specifically saying what's already in existence, and then you say what the improvement is or the inventive feature. There are a few ways of doing two-part claims, which I'm not going to go over in this episode, and I've actually never received any notice to change the claims in the PCT application to require a two-part claim. So even if you don't do a two-part claim in the PCT application, you probably will get a notice if you ever apply for a patent in Europe. In a way, reading claims in the two-part format is easier to figure out what the invention really is about, because you could list 20 things in the claim, and you're trying to figure out what's really new about it, and that can be hard to do in a one-part claim. But in the two-part claim, it's easier to focus on what the inventive part is. Technically, you can write claims in this format in the US, and they're called Jepson claims, but it's actually rarely done. In the US, we have this attitude of don't admit anything you don't have to, and anything you say can and will be used against you in a court of law. So we don't tell the patent examiner specifically what we think the prior art in the claim is itself. We let the examiner figure out what might be relevant prior art on their own. For US applications, you still have to disclose any prior art you know about, but you don't do it in the claim section. You do it in the information disclosure statement, which I've talked about previously. Which brings us to another difference in PCT and US applications. In the US, you have to list any prior art that you know of that might be relevant to the patentability of your invention. But for the PCT application, you don't have to list or acknowledge any prior art that you know about. Another difference is how many claims you might want in your PCT application. In the US, you're only allowed 20 total claims and 3 independent claims before you have to start paying extra fees. The PCT application doesn't have any limit on the number of claims you can have. Instead, you just have a limit of 30 pages of an application before we have to start paying extra fees, and it's $15 per extra page currently. So you might think, okay, no claim limit, why don't I just add hundreds of claims to my PCT application, and maybe the PCT examiner will find at least one of these claims patentable. There are some applications that have hundreds of claims, but in general, it's not a great strategy. If it takes you writing 100 different things down that are non-obvious over each other, then you've not really been thinking about what your invention is and what's patentable. Each dependent claim should really have something in it that's new and non-obvious or inventive over your independent claim. I've talked about that in the claims episode because if your independent claim is found to be obvious, then adding a bunch of obvious dependent claims doesn't really increase the patentability of your invention. There are some other differences, such as the standard of whether there are multiple inventions in your application, where you might be required to have to pay for different inventions separately. But we're really getting pretty technical here, and this is just an introduction to some of the main points of difference. In reality, even if you don't change anything from your US application, and your US application is written well, for the most part, it probably will be a decent PCT application with usually some very minor revisions. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.